Yesterday, my DoorDash driver who brought me my morning coffee and muffin wanted to tell me all about this new game, Palworld. When that happens, you know it's taken the world by storm. But are Palworld's days numbered? Let's talk about it this week on It's All Doug in Games. Hey folks, it's Doug from It's All Doug in Games. I had no idea what Palworld was until yesterday morning, and boy, I gotta tell you, I noticed that pretty much everyone online, on social media, on YouTube, is all aflutter over this new game that's suspiciously looking an awful lot like Pokemon, but with weapons. Palworld has sold millions of copies. I believe it's up to now 6 million downloads at the time that we're recording this. That's a massive amount of money. That's a massive audience. It's a massive game. I believe it is currently now surpassed Cyberpunk as the most played Steam game. So it's just incredible that something came out of nowhere. And I'll tell you what, I don't think that that's basically an accident, because again, it's tough for me to get behind video games because I've played so many. I'm getting older. It's harder to hold my attention. But I got to be honest with you, I was up all night playing Palworld last night, and it really intrigued me. As many other content creators have said, it's sort of a mishmash of gameplay elements, not just from Pokemon, but from everything from survival games to Breath of the Wild style gameplay to Fortnite to Minecraft. There's all these different elements in there, and they coalesce really, really well. There's just enough of that to keep you constantly motivated to do the next thing and the next thing, and none of it is overly tedious. So I gotta tell you, it's not just that 6 million people took a swing at this game. I think 6 million people are genuinely enjoying this game. And if nothing else, it's an embarrassment to the Pokemon company, who has absolutely been stagnant in the last set of years, just rehashing and actually devolving their existing formula and gameplay. Here comes a company out of nowhere that no one saw, that showed how the Pokemon formula could have, no pun intended, evolved. But is this Pokemon alike going to meet the standards for copyright infringement? So I'd like to take you through 3 court cases that happened over the course of video game history that kind of set some important precedents when it comes to what is or isn't an infringing copy of a video game. The first one goes all the way back when I was a kid, early 80s. Pac-Man. Everyone knows Pac-Man. I think even the younger kids know Pac-Man. That yellow guy, he eats things. Believe me, it was all the rage when I was a kid, and it was the bee's knees. Well, anyway, Pac-Man came out, and it set the world on fire, and Atari got the rights to bring Pac-Man to its Atari, 2600. And also basically saying, we're the only company that can make a home video version of Pac-Man. And they did. And despite it not being the most faithful Pac-Man port, it still sold millions of copies. Well, Magnavox, who had the Magnavox Odyssey 2, which was like this video game system that was a lot less present in the marketplace. There were usually like 4 kids on the block that had Atari, maybe 1 with Intellivision, and then there was a kid 3 blocks away with Magnavox Odyssey 2. But they were doing their best to try and compete, and they decided to test the waters and make a game called Casey Munchkin, which I think when you look at the art for Casey Munchkin, you think about what would happen if Pac-Man went to a rave and ate a glow stick. But nonetheless, I mean, you look at it and it's like, well, that's Pac-Man, just freaky acid trip Pac-Man. Well, nonetheless, Casey Munchkin comes out, and it's in the marketplace, and Atari gets wildly pissed off about this, as you would imagine, rightfully so. There's so much money on the line here. So they sued to try and get Casey Munchkin taken off the shelves. Now, the original decision that came down was that Casey Munchkin was not seen to be infringing because there was a legal principle that you have the idea of a game and the expression of a game, and that the idea of a game was not subject to copyright. The expression was, but the original judge just didn't quite see much of a connection there. Now, Atari, wanting to keep this thing going, appealed that, and the appellate judge saw things differently and said, oh yeah, acid trip Pac-Man and Pac-Man, very similar. Casey Munchkin's got to go. Now, that was kind of a catharsis because by the time all that silliness worked through the court system, the life cycle of Casey Munchkin was already gone, and Magnavox had wisely and cleverly made a sequel which had nothing to do with Pac-Man and had already replaced the original Casey Munchkin on the store shelves. However, a legal precedent had been set, and that's why I bring it up. So there is this concept of the idea of a game and the expression of it. Now let's fast forward to 1994, and here is a situation where Capcom was also setting the arcade world on fire with Street Fighter II. No one ever talks about Street Fighter 1, by the way, but Street Fighter 2, that's the one where everything just kind of coalesced. Believe me, in 1994, let's see, I don't want to admit how old I was then, but I was in the arcades hanging out, and there was just a row of Street Fighter 2 machines, so it was just everything. And as you might imagine, other arcade game makers wanted a piece of that sweet street fighting pie. Saying that 10 times fast. So Data East comes out with Fighter's History. And again, if you look at them side by side, clearly there's some inspiration going on there. Well, nonetheless, that inspiration was enough for Capcom to slap them with a lawsuit right between the eyes. Now, in this case, the judge ruled that there was no infringement, and it was kind of based on the idea that, well, to grant copyright to a game whose idea was basically just people fighting in the street, it was way too broad of a concept, and if they gave Capcom the copyright protection of that, it's effectively a monopoly on a very broad idea. So, unfortunately, Capcom was not able to bring Fighter's History out of the arcades. It survives, and to this day, of course, if you really feel like you want to play a crappy Street Fighter 2 knockoff, check out Fighter's History. Data East fans, let me know in the comments below. Now, finally, the third case I want to bring to your attention comes in 2012. And this one is really interesting because there's a lot of parallels to what's going on with Palworld. So you have Tetris Holdings, LLC, which is a legal holding company for the IP for the, of course, classic game Tetris. Now, they decided to take some legal action when they attempted to file a takedown notice for app stores that were selling a game from a company called Zeo Interactive called Mino. And Mino was, for all intents and purposes, a Tetris clone. And Mino, not unlike Palworld, had millions and millions of downloads at the time that legal action commenced. So long story short, they tried to do a takedown notice. The App Store said you got to have a legal, case to enforce it. So they took them to court. And in this case, the judge took a lot of the different concepts from the other cases and said, well, the idea of Tetris, of blocks falling from the sky, needing to be rearranged in a certain geometric pattern to score points before they all topple over, that's not copyrightable. But the presentation of Tetris, the expression of it, can be. And in this case, they took no real effort to make unique visual elements, visual expression of this game. And so, Mino had to hit the bricks. So Tetris won that case, and of course they nuked Mino from orbit, and so that game is no longer. And that's interesting to me because now then it kind of circles back around to where we are now, and perhaps what I suspect might actually happen in a court case here is Palworld infringing on the idea of Pokemon, which means really kind of the rule set and core gameplay ideas, or the expression, the visuals of these pals, just like Pokemon. And of course, the internet sleuths out there are all over the internet comparing every little visual detail of each pal to the appropriate Pokemon they're inspired by. So it will be very interesting to see in court if these visual similarities equal infringing expression. And to be clear, this is why I don't think that whether or not AI was used in the development of Palworld matters. Again, AI within this context, regardless of what you think about AI, is in terms of ethically or your feelings about it. In court, feelings don't matter. AI is basically an employee of the company that creates this game, just like Steve from the art department is. So whether Steve's drawing these potentially infringing pals or AI is, it's no matter in terms of the actual legal ideas and concepts that are going to be applied to it. Now, having said that, man, I'll restate this. I fell in love with this game. So it's not just 6 million people that download it. It's millions of people that are currently loving it. So if things go sideways, boy, you're going to have probably some virtual people in the streets very unhappy. I kind of like to know where you stand on this. Let me know in the comments below if you think my legal analysis is astute. Well, as always, thank you so much for tuning into It's All Dug in Games. It's my pleasure to do this. Please like and subscribe if you enjoy the cut of my jib. And as always, I'll see you next time on It's All Dug in Games.